how you feel coming out of this hearing here today?
We thought the hearing went very well. We're happy that the judges will continue the case to go forward in March of 2017. We've learned a lot in this civil litigation. We've taken now 17 depositions, which are sworn interviews under oath of numerous witnesses, including the roommates of both George and Yardley, the chief medical examiner for the Commonwealth of Virginia who did the autopsy, the detective in the Charlottesville Police Department who led the investigation, and many other witnesses. And the facts are all pointing to the same thing. This was a terrible accident. It was an unintended event. George didn't intend any of this to happen. George would be the first to tell anyone, as he continues to say to this day, that he is legally responsible for what happened. And that is both in the criminal context and the civil context. That's very different than an allegation that he intended any of this. It was a horrific accident, and we're happy that the evidence is continuing to support that. And we're happy that the brief filed by Sharon Love and the District Court in Maryland supports really the same argument. This was an accident. George didn't intend it. The physical injuries to Yardley were actually quite limited. She had a bruised right eye and a scrape under her right chin and a small amount of blood under her neck. That's what the limit to it. And the roommate returned. They suspected alcohol poisoning. That's what the quality evaluation was all about. There was no sign of a struggle. The apartment remained neat. The neighbor who was in the apartment below Yardley's heard no signs of an altercation. She just heard one loud thump, which she described as a heavy bookcase falling to the floor. We believe what happened was that George and Yardley were having a discussion on Yardley's bed when they fell to the floor, and that's the sound that she heard. Our medical expert, Dr. Jonathan Arden, who is a former chief medical examiner in the District of Columbia, has looked at the evidence and has reached the same conclusion. So, any other questions?
So I was going to say, so if you can break down then your plea in bar here is that she's saying a statement in Maryland that contradicts, I guess, some of what is happening in this lawsuit here?
Yes, in this lawsuit, Sharon Love has alleged 5 causes of action, 5 counts against George. The first is the simple negligence, which George largely does not contest. But then some of the other counts are very specific intentional acts, and we don't think the evidence supports that, and that the allegations as alleged by Sharon Love, if accepted, would support that either.
And what about the judge's comment? And I guess the plaintiff said this too, that the evidence is circumstantial enough that it seems like it might be a good idea for a jury to make that decision instead of a judge.
Well, we expect the judge, he's an excellent judge, he's going to make a very reasoned decision, and it's a good point that he raised. But when I look at the evidence and the allegations and the requirements under Virginia law for an intentional act, it doesn't appear to us that the facts as they occurred support the idea that this was anything intentional. It was a terrible, tragic accident.
So did the jury get it wrong?
That was a criminal matter. I wasn't involved with it. I'm not really commenting on that. They wrestled with a very difficult decision. What we're concerned about is the civil causes of action and what we think that evidence will show.
If the judge rules in your favor, do the statement of facts from the Maryland case become the statement of facts used in this case here, in the civil part of it, or what would a judge's ruling in your favor do?
Well, it's somewhat complicated. It will really depend on the specifics of the ruling, but we have all the confidence that the judge will consider the law and the facts, and as I said, he's an excellent judge, and he'll make the right decision.
I might be wrong here, but the impression I'm getting is that she used a certain statement of facts in Maryland, and you all are saying what she said in Maryland contradicts what she said here.
Well, she hasn't really made a statement of fact here. She's made general allegations of the types of causes of action recognized in Virginia. And when she filed her initial complaint, she's allowed to do that. She's allowed to do what's called pleading in the alternative, where she can say that it was both an accident, but also say that it was an intentional. And that's fine, and that's what she did. But once she takes a factual position anywhere about what happened, she's bound by those facts. And it's our position that the factual position taken in Maryland only supports the idea that this was an accident. It does not support the idea that it was intentional. And therefore, the motion was filed, and it's asking the court to throw out the intentional allegations against her.
What happens if the judge, in the summary judgment of Chartis, says that Chartis is not, I guess, up for the litigation?
Well, that should have no bearing on the plea in bar. She's taken a factual position, and it doesn't really matter which way the judge rules. The important thing is that Sharon Love has been provided a description of what she thinks happened on May 2nd and 3rd, 2010, and she's now bound by that statement.
A young man in prison for over 20 years, no assets. Why fight this so much?
I'm not really going to get into the specifics of that, but I'll say this. We have done an incredible amount of work in this civil litigation. We've had tools at our disposal that simply don't exist in criminal litigation. And specifically, that's the ability to take a deposition where we can subpoena all the witnesses. Now, most of them have come voluntarily. We can sit down in a conference room and take a lot of time to investigate what went on. Both sides are there. Sharon Love has been represented throughout in all these depositions. And we ask questions and we patiently dig up the facts. And that's allowed us to really learn and get a better idea of what happened. And we think we're going to be able to tell a very full story when we get to trial of this in March 2017. And while that will not affect the criminal sentence, it's important that a fuller truth come out. And we think that truth is the most important. This was a terrible accident. When George went over there, he had absolutely no idea. Anyone who's seen the police interrogation video, which is available on YouTube, clearly establishes that he was shocked, completely disagreed with this attack. The physical injuries that were described by Sharon Love, they're limited. It was a surprise to anyone. They were fatal. But it's what happened, and we're now dealing with the consequences. But we look forward to the civil trial, and we think a fuller truth will come.
Can Ms. Huguely tell us a little bit about how this has affected the family?
I would ask, her name is Marta Murphy, and Ms. Murphy is prepared to agree to witness.